And good afternoon, good morning, good evening for those who attend online. This is the 4th year we organize the Maritime Arbitration mock hearings during the Hong Kong Maritime Week. We do so to illustrate how arbitrations, which are usually held in confidence, are carried out. We want to show you arbitration as a premium option for dispute resolution. We want to demonstrate with joint effort Hong Kong's strength as a regional leading dispute resolution center. Speaking of which, allow me to introduce our first speaker this afternoon, Mr. Clifford Tavares. Mr. Clifford Tavares is the Deputy Law Officer of the Department of Justice of the Hong Kong Special Administrative Division. He joined the department since 2002 and has worked in different units of the Civil Division. Over the years, he specializes in civil litigation and has extensive experience in advising on public law, immigration, commercial, and competition law matters. In his current post, he oversees the work of the adversary and litigation teams relating to town planning, environmental protection, land, building and housing, as well as supervises the mediation team and the arbitration team of the Department of Justice in developing and promoting mediation and arbitration services of Hong Kong. Mr. Tavares has the mediation team in supporting the work of the steering committee of mediation chaired by the Secretary for Justice and implementing various policy initiatives, including biannual mediation week and the immediate first pledge event, the promotion of the use of mediation in the Greater Bay Area, the ICC International Commercial Mediation Competition, Hong Kong and Investment Law and Investor State Mediation Training Course. He is currently a member of the Judiciary Working Party on Mediation. Mr. Tavares also leads the arbitration team in supporting the work of the Advisory Committee on Promotion of Arbitration, chaired by the Secretary for Justice, as well as the advisory body on third-party funding of arbitration and mediation. So to address the welcome remarks, ladies and gentlemen, Mr. Tavares.
Thank you very much, Brad, for the kind introduction. Distinguished guests, ladies and gentlemen, it is a great pleasure for me to speak at the 2021 Maritime Mock Arbitrations as part of the Hong Kong Maritime Week. Let me first express my sincere thanks to CITEC Hong Kong Arbitration Center, CMAC Hong Kong Arbitration Center, Hong Kong Maritime Arbitration Group, Hong Kong Maritime Law Association, Hong Kong Institute of Arbitrators, and Chartered Institute of Arbitrators, East Asia Branch, for inviting the Department of Justice to co-organize this year's event. Since 2018, the mock arbitration event has been held annually to provide a platform for exchanges among maritime stakeholders and practitioners. The mock arbitration showcases typical legal issues and procedures involved in a real arbitration to enable the audience to understand the common practice in maritime arbitration proceedings. Adopting a hybrid form as in last year, the mock arbitration also provides precious insights into the way in which technology can be used to overcome the constraints of the pandemic, to reduce costs, and to advance towards green arbitration. Over the past few days of the Hong Kong Legal Week, as well as the Hong Kong Maritime Week, I'm sure many of you have heard a lot about the benefits of resolving maritime disputes through arbitration. Indeed, arbitration is the most commonly chosen method in shipping disputes, which involve highly complicated and technical issues. Without repeating what has been shared, I wish to highlight one of the most crucial factors underlying parties' preference for arbitration over litigation, that is party autonomy. In a maritime arbitration, parties can freely choose to appoint their trusted persons with the specialized skills and knowledge in the shipping area to arbitrate the dispute by way of a final and binding award. Legal practitioners may also be engaged to advise or represent parties in the arbitration. So experience and skills in shipping and arbitration cases are of utmost importance to parties' choice of arbitrators and advisors. With over 150 years of maritime history, Hong Kong has developed a deep pool of well-educated, multilingual, and globally experienced talents to provide a wide range of maritime services, including maritime arbitration and dispute resolution. To date, we have over 940 Hong Kong law firms and over 80 foreign law firms, many of which provide high-end maritime law and arbitration services to shippers, ship owners, and commodities owners in different aspects, such as ship financing, shipbroking, and maritime insurance. Being the only common law jurisdiction in China with plentiful know-how in the operation and regulation of international trade, Hong Kong has thrived in providing high value-added professional maritime and dispute resolution services. Whilst priding ourselves in the strength of our existing talents, the Hong Kong SAR government has been taking various forward-looking measures to develop a robust and sophisticated legal and maritime workforce so as to best serve our users. Here, I would like to share with you some of the key initiatives on nurturing our talents locally, regionally, internationally, as well as attracting talents to Hong Kong. The Hong Kong government attaches great importance to nurturing young legal and shipping talents. A wide range of maritime-related academic programs and training courses are provided by universities, the Vocational Training Council, and other education institutes in Hong Kong. To build up a diversified pool of professionals and technical personnel, the Maritime and Aviation Training Fund came into operation since 2014 to provide financial support to training schemes and scholarships of the maritime and aviation sectors. In terms of arbitration, the Hong Kong Institute of Arbitrators, Hong Kong Maritime Law Association, and Chartered Institute of Arbitrators have played important roles in training maritime lawyers and arbitrators. In recent years, various large-scale maritime-related events have been held in Hong Kong to foster exchanges and capacity building in the maritime sector, one of which is, of course, the annual Hong Kong Maritime Week, organized by the Hong Kong Maritime and Port Board. The week-long maritime-related activities and forums connect different stakeholders in the maritime industry for in-depth exchanges on the latest maritime-related topics, contributing to the development of the global shipping industry. Just a couple of weeks ago, the first World Maritime Merchants Forum was held in Hong Kong. The forum attracted participation of mainland officials, international shipping organizations, and various industry heavyweights. The inaugural Greater Bay Maritime Forum held in Hong Kong on Monday, and the Forum on Maritime Dispute Resolution in Hong Kong, Current and Future on Tuesday, were also a huge success in bringing together the industry together to discuss important maritime-related issues. To equip the profession with the ability to embrace online dispute resolution amidst the post-COVID new normal, various moot competitions have been held with the support of the eBram Center, an online dispute resolution and deal-making platform supported by the Hong Kong government. These competitions include the Virtual Business Moot, the ICC International Commercial Mediation Competition Hong Kong, and the FDI Moot National Round. Of course, the signing of the two memorandums of understanding on Monday, the MOU on cooperation and promotion of international maritime arbitration, and the MOU on cooperation in professional exchange and development, established the basis for exchange of expertise, cooperation and promotional and capacity building work, and enhancement of professional standards in maritime arbitration among the signing parties. Together with today's mock hearing, which is held simultaneously on-site and online, all these events contributed to capacity building and training for professionals and students from different parts of the world. Nowadays, it is not disputed that the powerhouse of international trade has gradually shifted to the east. Today, 9 of the top 10 container ports worldwide are situated in Asia, and 7 of them are in China, including Hong Kong. Hong Kong is the gateway to mainland China under one country, two systems. In the National 14th Five-Year Plan and the GBA Development Plan, China sets out clear support for Hong Kong to develop and enhance its status as an international maritime and dispute resolution center to provide high-end maritime services such as ship management and leasing, ship finance and dispute resolution services. In this connection, we have concluded a number of arrangements with the mainland courts, ministries, and other organs to enhance mutual legal exchange, cooperation, and training. Recently, with the staff support of the Ministry of Justice of the PRC, the first GBA legal professional examination was held in Hong Kong in July this year. With relevant legal training arranged by the Ministry of Justice, over 650 Hong Kong lawyers enrolled for the examination. The examination provides a channel through which the Hong Kong legal service sector may gain the opportunity to provide mainland legal service, including maritime-related advice in the GBA. In recent years, both the volume and complexity of cross-border shipping disputes have increased dramatically. Keeping abreast of the global trends is a key to harnessing the opportunities available in the maritime, legal, and dispute resolution sector. To broaden our local talents' knowledge of international legal developments, the Department of Justice has put in place a common programs with various renowned international organizations, namely Asian Infrastructure Investment Bank, United Nations Commission on International Trade Law, Hague Conference on Private International Law, and the International Institute for Unification of Private Law. Through these programs, local young legal talents can participate in the work of international organizations and develop global vision in international legal matters. Other than local talents, one of the main policies in the Chief Executive's Policy Address 2021 is to bring in talents from around the world. The talent list, first drawn up in 2018, aims at attracting specified types of talents, including marine engineers, superintendents of ships, and legal dispute resolution professionals. Looking forward, not only will the annual quota of the Quality Migrant Admission Scheme be doubled to 4,000, our talent list will also be refined to attract top-notch and experienced marine insurance and dispute resolution professionals to Hong Kong. Today, the global maritime industry is faced with two prominent trends: digitalization and decarbonization. Digitalization initiated transitions to new technologies such as automation, artificial intelligence, and smart shipping, complemented by new industry regulations, including the Guidelines on Maritime Cyber Risk Management issued by IMO, the Cybersecurity Workbook on onboard ship use recently published by BIMCO and ICS. The UK Law Commission is also finalizing its proposals on allowing for legal recognition of electronic trade documents, such as bills of lading and bills of exchange. Likewise, for decarbonization, the environmental regulations of the IMO have been expanded with the long-term goal of reduction of carbon intensity and greenhouse gas till 2050, impacting a ship's choice of fuel types, equipment, and the check of carbon intensity. These new standards have also prompted ESG policies, which become essential for sustainable underwriting. With all these new norms and developments coming into play, the ability of maritime stakeholders to stay alert to the global changes is pivotal. Consistent with our ongoing work and initiatives, the government will continue to collaborate with the shipping industry, both in and beyond Hong Kong, in organizing different capacity building activities so as to ensure that our talents are well equipped to provide the necessary support in the face of the ever-changing demands of the maritime industry. On this note, I would close by wishing today's mock hearing a great success. Thank you very much.
Mr. Tavares, and as a member of the arbitration community in Hong Kong, it's always delighted for us to hear continuous progress and initiatives of justice for the promotion of arbitration. Now, ladies and gentlemen, this afternoon we are going to have mock hearings of two parts, one for the procedural matters and the other for the substantive matters. For the procedural matters, we are going to hear parties to discuss on the matter of jurisdiction and challenge of arbitrators. As I have been understood, there have been members joining us online who are not quite familiar with arbitration proceedings. So let me put it into the simplest. So you will hear parties in the procedural matters to discuss whether or not CMAC Hong Kong Arbitration Center an appropriate venue to resolve this particular arbitration case. And you will hear parties also argue about whether or not whether one of the members of the tribunal is a suitable person to decide on matters. So that's the procedural matters. For the substantive matters, we will hear counsel from both sides to discuss on the issues of delay, deviation, and compensation. So without further ado, let me first invite arbitrators to be presented in the stage, and I'll introduce them one by one. I please invite Donald and Jackman, please. We also have Mary online. Mary, can you hear us?
Yes.
Great. Thank you, Mary. You look wonderful on the screen, as always. Hope you can join us here.
Well, I was expecting someone to provide me a virtual background like Adela's, but I haven't seen one, so I'm bringing color to the proceedings.
You look fantastic in front of all those colorful trees, I would say. Let me introduce the arbitrator, Ms. Mary Thompson, first. Ms. Mary Thompson is the past chair of the Chartered Institute of Arbitrators of East Asia branch. She is immediate past chair of Arias Asia, member of ICC Commission on Arbitration, former board member of Arbitral Women and the East Woods, and board member of Scottish Arbitration Centre. After qualifying as a barrister in London, she worked in transport and insurance industry before returning to private practice and requalifying as a solicitor in London. Mary practiced at solicitor firms in London and Hong Kong for 25 years, focusing on commercial dispute resolution for the financial and commercial sectors. She has been appointed as arbitrator since 1996, including pursuant to commercial net forces. In 2013, Mary joined the Hong Kong bar and rejoined the English bar to focus on full-time practice as an international arbitrator and mediator. She regularly sits in arbitrations in London, Hong Kong, and Singapore. Next, in front of us, Mr. Jacques Makar. A unique combination of academic prowess and experience in commercial shipbuilding, ship management, dispute resolution, and senior management roles define Jacques' career. Jacques is the IMEI chair at the Indian Maritime University, board director of the Global Maritime and Education Training, Global Met, and ambassador at Asia at the Baltic Export Winners Association. Jacques is an independent maritime arbitrator and an expert witness with focus on dry shipping. His area of expertise includes charter parties, ship sale and purchase, shipbuilding contracts, and ship finance in commercial shipping, as well as ship management, ship repair, contract disputes. Jacques is a member of the Hong Kong Maritime Arbitration Group, supporting member of London Maritime Arbitrators Association, panel arbitrator of Singapore Chamber of Maritime Arbitration, China Maritime Arbitration Commission, and is on the list of arbitrators of the HKIAC. Jacques is the chairman of the Institute of Chartered Shipbrokers, Hong Kong branch. Last but not least, we have our presiding arbitrator today, Mr. Donald Shang. Donald is a partner in the litigation department of the Hong Kong office of Smith Richards Butler. Donald specializes in Hong Kong court litigation and international arbitration proceedings. He has extensive experience in handling complex and high-value matters involving multiple jurisdictions, as well as matters requiring interim relief, such as emergency arbitration proceedings, asset preservation measures, disclosure orders, anti-suit injunction, and ship arrests. He regularly advises on insolvency issues. The Legal 500 2021 ranks Donald as a rising star in international arbitration in Hong Kong and describes him as very impressive, very professional, and very responsive, and that he is very familiar with arbitration and litigation procedures and provides clear and commercial advice. He's also recommended by Doyle's Guide 2021 as one of the leading Admiralty maritime shipping lawyers in Hong Kong. Without further ado, if I may invite counsel for the procedural matters to be on stage, and I expect also Ms. Adela Mao joining us online. Adela, can you hear us?
Yes, I can hear you.
Thank you. We have everyone on set. So everyone, if you'd like to speak, please open up your mic first. Yes, I can be assisted further. Come on, the floor is yours. Interest.
Oh,
yes.
Hello, can you hear me? Afternoon, ladies and gentlemen. Good morning, Ms. Thompson, Ms. Mao. who are participating in this arbitration virtually from the UK. This is the oral hearing of the arbitration between Ship Owner Limited and Charterer Limited in relation to a voyage charter party dated 21st of July 2020 for the chartering of the vessel Third Wave. In a real life setting, the tribunal would have already received a list of attendees from each party, so there's no need to introduce anyone. But for the purpose of today, may I ask counsel to introduce your legal teams to the audience.
Hello, we're representing the claimants on this case. My learned friend, Mr. Moses Park, and myself will argue on the procedural issues, and we are both barrister of Liberty Chambers.
Hi, this is Adela. I'm counsel for the respondent, and I will be the sole advocate for the respondent. Thank you.
Thank you, counsel. This is the procedural part of this mock arbitration. And before we start, maybe I would first clarify for the purpose of the audience that this procedural part will consist of two parts. The first part is the jurisdictional challenge, and this will be decided by the tribunal under the CMAC rules. The second part is about the challenge to an arbitrator's qualification or impartiality. And the latter part is actually decided by the CMAC chairman. But for the purpose of today, the tribunal will hear submissions from the parties, and the arbitrator concerned can decide whether to resign. And if it doesn't, then we will continue the arbitration pending the CMAC chairman's decision. If there's no other housekeeping matters, counsel, may I ask you to please proceed with your oral submissions?
Yes, as the applicant for the jurisdictional challenge, the respondent will go first. Good afternoon, Mr. President, members of the tribunal. Before I start, I want to inform the tribunal and also the audience, who I assume that you're not here in the room where I'm going today. The tribunal will no doubt have received the parties' written submissions. Indeed, both parties have taken the tribunal through the case law and the academic literature on the important question as to the proper law of an arbitration agreement, which requires no repetition today. I will go through the framework of analysis for the purpose of clarity, with an express intent of placing the claimant's arguments, all three of them, in the context, which I will emphatically respond to. But before I even embark on that exercise, can I raise an anterior issue of an insurmountable limit in principle and in practice of the claimant's arguments, which is the consequence of splitting a contract because of the seat of the arbitration? It produces no easy answer as to why all the arbitration-related or peripheral obligations, other than the obligation to arbitrate itself, should be governed by a different system of law. It will give rise to very difficult questions, especially when there is a term which is defined in the main contract, and the same term is defined in the arbitration clause per se. And there will be a question as to what meaning should be given to that term, because based on the claimant's arguments, there will be two different systems of law that should apply to the interpretation of the same term in the different clauses within the same contract. Now, without further ado, I wish to proceed on the respondent's jurisdictional challenge. The tribunal will have the charter at page 1 of the bundle, and the tribunal will see the dispute resolution clause at paragraph 1, which, for the benefit of the tribunal and the audience, reads, arbitration at any institution in Hong Kong, governing law is Chinese law. And there are three common grounds between the parties. The first one is that the governing law of the charter is Chinese law. And the second is the parties have chosen Hong Kong law, Hong Kong as the seat of the arbitration. And the third common ground is that the arbitration agreement is valid under Hong Kong law and valid with some qualification according to Chinese law, because the arbitration institution is not named. And the issue before this tribunal, as I have alluded to earlier, is that where the parties have not specifically chosen the law governing the arbitration agreement, which system of law should apply. And I wish to pause here to emphasize the word specifically, because in the case law, there's always a reference as to the situation where the parties have not expressly chosen the law governing the arbitration agreement. In my respectful submission, this case and similar scenarios should be better clarified as classified as a situation where the parties have not specifically chosen the law, because as my arguments go, the parties have expressly or implicitly, impliedly chosen the law governing the arbitration agreement. And there is a long line of authorities which both parties have taken the tribunal through in their written submissions. There is a two-stage inquiry as to what is the proper law for the arbitration agreement. The first stage is, as I have stated, whether the parties have made a choice, whether expressly or impliedly, as to the proper law. And only when there is no such choice, I emphasize that point, will the tribunal proceed to consider what is the law that is the most closely connected to the arbitration agreement. And as the tribunal will recall from the claimant's arguments, the third main plank of the claimant's arguments is that the seat of the arbitration is most closely connected with the arbitration agreement, hence Hong Kong law should govern. And in my respects for submission, we don't have to go to the second stage of the inquiry, because there is a choice of a proper law governing the arbitration agreement. And I will ask the tribunal, in construing whether there is a choice of proper law governing the arbitration agreement, to bear in mind two principles of common law, fundamental principles of common law, which is that the tribunal will not rewrite the parties' contract. This has some bearing as to the validation principle, because, and I want to emphasize that the only exception to override the parties' contract is the ground of public policy, and we obviously are not proceeding in that line of argument. There is an argument that because of the consequence that follows from choosing Chinese law as the governing law of the arbitration agreement, there will be a general inference that the parties have certain intentions. But in my respect for submission, that is an overgeneralization of the position. And as the tribunal will see from my written submissions, that is a matter of degree. And I will return to that point. And the second point is that when, as I have emphasized, the tribunal will exercise caution in my respect for submission when it decides to proceed to the second stage of inquiry and essentially impugn on the parties an intention that was not there at the conclusion of the contract, merely because there is a different system of law which has some relationship with the contract. The claimant's first main plank of their arguments is in fact the respondent's burden of proof. And the tribunal, in my respect for submission, the tribunal will not see that burden of proof as an extra hurdle for the respondent, because in satisfying the tribunal as to there is an express or implied choice of arbitration agreement, the respondent will be discharging its duty and there is no extra hurdle. The tribunal will see that from the line of authorities that the parties will be presumed as having chosen the same system of law. And as I have highlighted at the beginning of my submissions, it takes very good reason or strong reason, in the words of the law lords, that the parties will be taken to have intended different systems of law to apply to the whole to the same contract. In my respect for submission, that only comes when there is an express or implied exclusion of the law, of the substantive law of the main contract to apply to the arbitration agreement. And that does not happen in the present case. And as to the second stage, which is that there is no choice of law, if there is no choice of law applicable to the arbitration agreement, the tribunal will start from a presumption that the same system of law applies. And there is a divergent view as to what follows from there. And in this arbitration, we have Hong Kong as the seat of the arbitration. That is the only connecting point of Hong Kong in relation to this arbitration agreement. And as the tribunal will be most familiar with, the usual overlap argument, which is if you choose Hong Kong law, if you choose Hong Kong as a seat of arbitration, Hong Kong law will inevitably be intertwined in the interpretation and validity of the arbitration agreement, no longer holds. So there's no additional reason to treat the connecting factor of the seat of arbitration as a special factor. On the other hand, we have mainland Chinese law as an express choice of law in itself. We have the one party which is located in mainland China, and we have the discharge port in mainland China. I'm pointing to the later two factors, not that they carry the importance per se, but put together, they should be seen, just speaking of the burden of proof that I need to discharge, they should be seen as factors pointing to the, as my learned friend has submitted to the tribunal, sophisticated commercial parties who have intended for the same system of law to apply. And in my respect for submission, it is an overgeneralized legal proposition that the law of seat is in general the most closely connected with the arbitration agreement because the overlap argument does not apply. And I think I have running short of the time that is allocated to me under the chess clock procedure. But I would be grateful if the tribunal will let me know if you have any questions, and I will allocate my time internally.
Thank you, Ms. Mao. Hello. Thank you, Ms. Mao.
Yes.
I wonder if my co-arbitrator has any question at this stage. Ms. Thompson, Mr. McCarthy.
Thank you, Counsel. Just one question that comes to my mind is, what is the intention of the parties, two commercial parties, when they get into a contract? Is it to have a valid arbitration agreement, or the intention right in the beginning is to render it invalid? Thank you.
Mr. Co-arbitrator, thank you very much for that question. My answer to your question is that the party's intention was to have the arbitration clause as stated in the contract. They probably have intended some consequence to follow from the arbitration agreement, but because of the choice of law, because of reasons that are not pertinent to this hearing, the consequence would not materialize in the event of the when the applicable law is decided. But that does not change the fact that the commercial parties have intended the arbitration agreement per se in such wording with an inadvertent consequence that they have not intended, and it is not for the tribunal to improve their deal. I hope I have answered your question.
May I now invite Ms. Wong and Mr. Park to make your submissions?
Thank you. I'll first address the first procedural issue, that's the challenge of jurisdiction. And then my learned friend, Mr. Park, will address the second challenge, that's the challenge of arbitrator. As a quick reply, and I'll elaborate later, I have 3 main points to make. First of all, my learned friends, the learned friend of the claim, the respondents, they have made the wrong test or adopt the wrong test. It's not a 2-stage test. Instead, it's a 3-stage test. And because my learned friend skipped the second stage, which requires the tribunal to look at whether there are any factors significantly undermine what my learned friend just said about the governing law. That means the governing law, it governs the substantive obligation of the party, as well as governing the arbitration agreement, okay? When the tribunal look at this first limb, then you have to look at the second limb, whether there are any factor undermine this interpretation of the contract. And indeed, there is such undermining factors here, as I'll elaborate later, okay? And then the third limb is if the tribunal decided that the governing law of the contract does not apply to arbitration agreement, and that happens in many cases, then the tribunal will have to look at which governing law applies. And in this aspect, it is well established in case law, as I will bring the tribunal to the case law. It is a last year's very recent UK Supreme Court decision saying that if the tribunal finds that there's no governing law on the arbitration agreement, I'll make it clear, I'll stress this point. Governing law on the arbitration agreement, we're not talking about governing law of the contract, because governing law of the contract is on the substantive obligation. It may not necessarily be the same as the governing law on the arbitration agreement. So if the tribunal finds that there's no governing law on the arbitration agreement, then, and the party has chosen a seat of arbitration, then applying the close connection test, the arbitration seat, the law governing the arbitration seat will be the law governing the arbitration agreement. I will bring the tribunal to the law on this area is well established. And we all know that in this case, the parties already chosen Hong Kong as the seat of arbitration. So in case if the tribunal finds there's no governing law on the arbitration agreement, then it must necessarily follow that Hong Kong law governs the arbitration agreement. Okay, that's the 3 stages test I will elaborate later. The second thing is a point raised by the tribunal member as well, is my learned friend throughout his submission, let me no mention of a very important fact. The parties here are well-established, experienced business firms. The contract we're having here is a business contract. So in business contract, in commercial contract, commercial interpretation has to apply. And the case law also well established that the interpretation is a purpose interpretation. That means you look at the purpose of the contract and then decide what will make the contract work, what will give effect to each contract clause. Not only 1 or 2 of the contract clause, but the interpretation that will give effect to every one of the contract clause, including the very important arbitration agreement. That's the second point I would like to make. Let me start with the 3-stage test. Before I go into the 3-stage test, that's one very important point we have to understand, because it will have a very, very influential on the result of this arbitration. It's a common ground of the parties that if PRC law governs the arbitration agreement, then the arbitration agreement is invalid. The entire thing goes out the window. However, if Hong Kong law governs the arbitration agreement, then the arbitration clause is valid. So this is the common ground, okay? And then let's look at the law. What's the current law? I mentioned that there's a UK Supreme Court decisions last year, and that decisions make it clear that there's the 3 stages test as far as this case is concerned. Because in this case, it's specified that the governing law is Chinese law. So according to the UK Supreme case, which is in the authority, and the case is Anchor Instance and Sensors versus Insurance Company CHOP 2020. And in this decision, the majority of the lordship make it very clear that the first limit is, if we see a governing law, then generally, I will stress generally, the governing law will apply to the arbitration clause as well. So, okay, in this case, we have the PRC. So generally, the PRC law will apply to the arbitration agreement. So that's the first limit. And that's the only area my learned friend covered in her submissions. Then she skipped the second and the third, very most important stages as well. The second stage, may I bring the tribunal to the authorities, because that would be very crucial. And that's authority, the second authority. And it's a very short paragraph, and that's on page, paragraph 170. Paragraph 170, the lordship summarized the law. It's a conclusion on applicable law, so it'll be very succinct. And then we can see that there's a several points, but as far as this case is concerned, on the second link, we can focus on the 6th point. The 6th point. So paragraph 170, the 6th point. Additional factor that the tribunal has to consider is that the first link, the inference from the first link will be negated in some cases if the arbitration agreement was intended to be governing by the law of the seat, or the A is not applied here, we can focus on B, is the existence of a serious risk that if governed by the same law as the main contract, the arbitration agreement would be ineffective. Simply put, it said that if the governing law of the contract applies to the arbitration clause, then if the result is that the arbitration agreement will be ineffective, then this will negate the inference mentioned by my learned friends that the governing law of the contract will apply to the arbitration agreement. Why? Because the court is applying a purposive interpretation of contract, of commercial contract. And in a Hong Kong case law, and that's in paragraph 12 of my submissions, is staying very clear that, first of all, the burden of proof is on the respondents to prove that. And then the burden of proof is very high. How high is it? The wording it used is that cannot with the best will of the world be performed. So in order to win this challenge, my learned friend has to prove that the interpretation with the best will of the world, this cannot be performed. There's no way, because we have another way out for this contract. In this way, another way out is we can say that the tribunal can find that the arbitration agreement is not governed by the PRC law. Why? Because if you use the purposive interpretation, the party enter into the arbitration agreements, they want to arbitrate the case. And they specifically pick Hong Kong as the seat for arbitration. The intention can't be clear, can't be more clear. And my learned friend never dispute the fact that there's a clear intention for the party to dispute the case in Hong Kong. So there's no way the intention of the party is to interpret the contract using the PRC law, because it will make it invalid. This is also the legal position adopted by the Supreme Court in the case I just mentioned, in the Anchor case, I just mentioned the second authorities. So applying the purpose interpretation, PRC law can be applied because it invalidates the arbitration agreement. The arbitration agreement, then the tribunal will have asked if PRC law doesn't apply, which law applies? That brings us to the third limb. And in the Anchor case, it made it clear that if there's no governing law on the arbitration agreement itself, then the law that applies would depend on whether the party had chosen a seat of arbitration. In this case, we know that we have chosen a seat of arbitration. And then the tribunal made it, the UK Supreme Court made it clear that once they have chosen the seat of arbitration, the venue that's most closely connected with the parties will be the seat of the arbitration. That's why the law of the seat of arbitration apply. In our case, that will be the Hong Kong law, okay? So that was my second point. The third point I want to rebut on my learned friend is that my learned friend said even if there's no law governing the arbitration agreement, under the close connection test, the seat of arbitration is not the place that's the most close connection, because he said that the overlap principle apply. That's not the case. Why? Because when the UK Supreme Court make the point that when there's an absence of governing law, the seat of arbitration apply is not based on the overlap principle. The UK Supreme Court indeed outlined many reasoning, underlying the reasoning why the seat of arbitration is the most closely connected. If the tribunal want, I can bring the tribunal to each of the factors underlying this reason. But I also can bring the tribunal to conclusion made by the UK Supreme Court, because that will be the easier. Because in the conclusion, you can see that this is summarized clearly by the UK Supreme Court. When I bring the tribunal to the second tab of the authority, paragraph 170, and then there's many subparts. So we can go to subsection 7. Subsection 7, that will be on page 4168. So that's the case here. The law is where there's no express choice of law to govern the contract. A clause providing for arbitration in a particular place will not by itself justify an inference that the contract or the arbitration agreement is intended to be governed by the law of the place. However, it said on 8, and 8 is the case that we are now arguing. In the absence of any choice of law to governing the arbitration agreement, the arbitration agreement is governed by the law with which it is most closely connected. Okay, so what's most closely connected? Where the party has chosen a seat of arbitration, this will generally be the law of the seat, even if it applies to our case as well, even if this differs from the law applicable to the party's substantive contractual obligation. So that's the case. The Hong Kong law differs from the governing law, but it's the seat of arbitration, so it should apply to the arbitration agreement. Thank you.
Thank you, Ms. Wong. Mr. Park, I believe you will begin your submission on your own application.
Yes.
Before Mr. Park goes on, can I just ask Ms. Wong a question?
Yes.
Ms. Wong, even if we accept from the submissions you have so kindly expressed cleverly, even if we accept that the seat of arbitration is in Hong Kong, the arbitration clause doesn't actually specify the institution. So how would you address the fact that we're now having CMAC as the institution that is administering this arbitration, where it is silent in the arbitration clause, even if we accept that arbitration should be Hong Kong?
Thank you, Ms. Thompson. The party has, while reserving their position to argue on the jurisdiction, the party has agreed that because the arbitration agreement said that any institution in Hong Kong, so the parties, they agreed to appoint this institution.
Okay, so presumably the other side has said that on a without prejudice basis, whilst they still challenge the seat, they are agreeable to CMAC administering. Is that right?
Yes, that's right. So CMAC's the agreed institution.
Okay, thank you. Thank you for the clarification.
Thank you.
Yes, just for the purpose of the mock demonstration, that is the consensus that we have. But in real life situation, I can imagine other arguments. For example, there is an implied agreement that the both parties have to agree on a nomination of an arbitration institution, otherwise it will be ad hoc. But just for the purpose of the mock demonstration, we're satisfied with the arguments so far. Thank you.
Thank you, Ms. Mao. We will not hold you to that beyond this mock arbitration, don't worry. Thank you, Ms. Thompson, as well for the question. Mr. Park, may I ask you to please begin your oral submission?
It brings me to the second issue on the challenge of the presiding arbitrator. Members of the tribunal, before you is the claimant's application. For the benefit of the tribunal and the members of the public attending this hearing, at the outset, please allow me to illustrate the relevant facts, because the facts, there are slight differences that have been made in the facts. First, counsel for the respondent, that is my learned friend, Ms. Mao, and Mr. Sham, the presiding arbitrator, are from the same set of chambers in Hong Kong, a very reputable set, if I may add. Second, it was recently discovered that Ms. Mao was led by Mr. Sham in a few international commercial arbitration cases in the past 3 years. Third, Ms. Mao and Mr. Sham have conducted professional seminars or appear in the same panel in numerous arbitration conferences around the region in the past few years. Fourth, Ms. Mao and Mr. Sham co-authored papers published in academic journals, including maritime arbitration textbooks. And lastly, before the tribunal was constituted, Mr. Sham failed to make full disclosure of his relationship, whether it be working otherwise, with Ms. Mao. It may be argued that the relationship is of professional nature, but we submit that non-disclosure of such relationship to the parties prior to the constitution of the tribunal is contrary to the principles of fairness, due process, and justice, which are part of Hong Kong's public policy. Of course, I will elaborate further on this point in my submissions later on. It may also be argued that barristers from the same set of chambers may be found in an arbitration case, one barrister acting as counsel for a party like Ms. Mao, and the other sitting as an arbitrator in the tribunal like Mr. Sham. We submit that although such is a common practice in the English common law world, given the fact that given the international nature of the dispute and the fact that parties are from different jurisdictions, such as Indonesia and mainland China, Mr. Sham must have disclosed the close working relationship he has with Ms. Mao under various settings. In these circumstances, we say that there was and is an apparent bias on the part of the presiding arbitrator, and that in order for these arbitral proceedings to conducted in a fair manner, ensuring the neutrality of the tribunal, Mr. Sham should voluntarily withdraw from his office and from this case. The legal principles are settled and we do not dispute them. The legal principle or legal test for apparent bias is explained in the John Science Information Technology case, which I cited in my skeleton, in our skeleton. If I, just for the benefit of the members of the public, if I just may read out that relevant part, whether an objective, fair-minded, and informed observer, having considered the relevant facts, would conclude that there was a real possibility that the tribunal was biased. Now, what is, or who is an objective, fair-minded, and informed observer, and what is the viewpoint of such person? We have set out this in our arguments, but I would like to draw the tribunal's attention to Mr. Justice Kirby's description of such person in the case of Johnson and Johnson. It's in our skeleton. And I'll read out the relevant passages. Such a person is not a lawyer, yet neither is he or she a person wholly uninformed and uninstructed about the law in general or the issues to be decided. And what the objective onlooker has to decide after having been informed of all the relevant circumstances is not whether it would be better for another adjudicator to hear the matter, but whether the adjudicator sitting to hear the matter might not bring an impartial and unprejudiced mind to the resolution of the dispute. The objective onlooker or observer should be, according to Mr. Justice Kirby's description, informed of all the relevant circumstances. An objective observer living in Hong Kong may be familiar with the English legal tradition of the split profession between solicitors and barristers, and that barristers practice independently in sets of barristers' chambers. We note Madam Justice Chen's view of a barrister's chambers in a similar context in the case of W and AW, where her ladyship says, the reasonable and fair-minded bystander would be taken to know that barristers share chambers, and that is the common place for professionals to associate, meet, and participate jointly in conferences and even in marketing events, and that this would not influence their professional decision-making in a case. However, an objective observer living in Indonesia or mainland China may not, and likely would not, be familiar with such legal tradition that we have here in Hong Kong. If that were to be so, then such facts should better be disclosed to the parties from different countries in order to ensure that there are no issues of impartiality or conflicts of interest. Mr. Sham's reputation precedes him in the international arbitration community for his many years of outstanding practice as an international arbitration lawyer. Given his extensive experience in international arbitration, we certainly expected that he would have the appreciation of the international nature of the dispute and the fact that parties are from different jurisdictions with different legal traditions. And yet no disclosure, nothing was made of his working relationship with Ms. Mao until it was discovered by others that there was such relationship, and thus we're making this challenge application. We would like to highlight that under Section 25 of the Arbitration Ordinance, an arbitrator has a continuous duty to disclose any circumstances likely to give rise to justifiable doubts as to his impartiality or independence. And we say that the circumstances in this matter give rise to justifiable doubt to Mr. Sham's impartiality. Members of the tribunal are familiar with the orange list of the IBA guidelines on conflicts of interest in international arbitration, and that the situations under the list may require disclosure. We accept that situations described under the list are generally not subject to disclosure. However, the IBA guidelines observe that it is up to an arbitrator who needs to assess the situation and personal circumstances that may give rise to justifiable doubt as to his impartiality and independence. There are 3 relevant situations set out in the orange list of the that are relevant for the present matter. The first is arbitrator and another arbitrator, or the counsel for one of the parties are members of the same barrister's chambers, which is set out at the orange list 3.3.2. Second, a close personal friendship exists between an arbitrator and a counsel of a party, 3.3.6. The arbitrator and another arbitrator or counsel for one of the parties in the arbitration currently act or have acted together within the past 3 years as co-counsel, 3.3.9, which is actually the most important factor that we have problem with. My last point on the decision-making power is this. Under Article 37 of the rules, the chairman of CMAC shall have the power to decide to replace the arbitrator. It also stipulates that an arbitrator being challenged his jurisdiction may voluntarily withdraw from his office. Given the circumstances of the case, as I explained in my submissions, we humbly submit that there is an apparent bias on the part of the presiding arbitrator, and that he should voluntarily withdraw from his office and from this case. Unless there are questions from the members of the tribunal, those are my submissions.
Thank you, Mr. Park. May I know if my co-arbitrators have any question at this stage?
I do.
Yes, Ms. Thompson.
Mr. Park, you presumably is familiar with the decision of Justice Riggs in Laker Airways and FLS Aerospace, where he said quite forcefully that some of the points you've already highlighted, that barristers are not a partnership, they do not share profits or income, and it is common that members from the same set of chambers appear on different sides, especially in large specialist chambers, that arbitration would become impossible if a party could just require an arbitrator to retire by making allegations of impartiality or bias, and that parties should have the freedom to choose the advocates of their choice. So in this case, there's one advocate who's from the same set as the arbitrator. The other point being that, this is a specialist area of arbitration. We're talking about a shipping dispute where you have a very small circle to draw upon. Do you think those are relevant in terms of whether the presiding arbitrator in this case should voluntarily retire or not, retire or resign? Because surely we have here counsels who are advisors, counsels who are familiar with the system and are in a position to advise their clients concerned.
Thank you, Ms. Thompson, for your question. I agree with you that barristers from the same set of chambers may appear as one acting as counsel, the other sitting as an arbitrator the tribunal. We don't have any issue per se with that arrangement. The issue that we have in this case is that there was no proper disclosure made by the presiding arbitrator of such relationship that he has with Ms. Mao, counsel for the respondent. Given the fact that, as I illustrated in my submission, that the parties are from different jurisdictions that are not familiar with the English legal tradition, Mr. Shen, the presiding arbitrator, is a very experienced arbitrator and has been practicing international arbitration for many years. And we expected that he would have the appreciation that the parties from different jurisdictions may not know of such fact. It is a well-known fact to us, but not to the parties in the case. And the non-disclosure issue is the very issue that we take up. We're not happy with.
So you're saying that if the disclosure was made much earlier, then you would have been happy to just go along with having the presiding arbitrator still.
As long as the parties knew of that relationship and were happy to proceed with the constitution of the tribunal, then there would not have been any issue with that.
Thank you, Mr.
Yes, Mr. McCall.
Thank you, Counsel. Thank you, Mr. Park. You said it was just a question of disclosure. Where would you go? Where do you draw the line to such a disclosure, especially when in today's environment, it is so very obvious and clear. You can find the information which is easily available. If people are working together in seminars or writing books together, it's information freely available. So where do you draw the line? Up to what level the disclosure has to be made? That's one point in my mind. And second thing is, if we say that a particular person is very well known and he has been doing what he has been doing, so is it not to leave it to his judgment whether the disclosure should have been made or not have been made? Thank you.
Thank you, Mr. McCall, for your question, which is a very good question. The real issue that we have with the relationship of the presiding arbitrator, Mr. Shen, and Ms. Mao, is the fact that they have worked together in arbitration cases as co-counsel. Ms. Mao was led by Mr. Shen in a number of arbitration cases. Now we know, as the members of the tribunal would appreciate, that the importance of arbitration is confidentiality, and who the parties are and who represented those parties. It is not public knowledge that Mr. Shen or Mr. Shen and Ms. Mao have acted as co-counsel in those arbitration cases. That's the real issue that we have in this case. Of course, they have attended different seminars and co-author textbooks. Although those are relevant factors, but those are not the real issue. But the real issue is they have worked together. There is a working relationship between the presiding arbitrator and Ms. Mao.
Thank you. Since we are running out of time, Ms. Mao, I just want to be conscious of time, but of course I would have to give you the opportunity to make your reply.
Thank you. I wish to start with the ramifications. arising from the exchange between my learned friend and the bench, which is a point that we should take, is that it is not to give parties in an international arbitration seated in Hong Kong free tickets to challenge their choice of counsel or to challenge the choice of arbitrator merely because they are allegedly unfamiliar or with the English tradition. And I think that the development has led to a migration of the issue, because I have heard my learned friend said several times that the real issue is about non-disclosure. So I will tackle with that upfront. There are a list of 5 challenges, and my understanding is that those had not been previously disclosed. But as rightly pointed out by Mr. Co-arbitrator, 4 of those list of challenges are public in the public domain, which I refer to all the challenges except for the fact that I have worked with the presiding arbitrator in a few arbitration cases. And with respect to the working relationship in arbitration cases, as my learned friend rightly pointed out, there's an issue of confidentiality. And as my learned friend has rightly pointed out, that the presiding arbitrator will exercise his judgments. Someone in his experience and standing will exercise his judgments. And we will hear from the presiding arbitrator as to the timing, as to the specific timing that he chooses, which is not privy to the party at the moment. My personal guess would be there might be some confidentiality clearance to be sought from the previous arbitrations. And that is one of the main issues advancing one of the cases that has taken on board by some courts when it comes to the challenge of the arbitrators. Another point that just follows from that point is that these confidentiality considerations are not to be taken lightly. And the failure to disclose, and I will have to supply with the tribunal the case law after the hearing, and I do apologize for that. But at least in one of the cases, it was said that the failure to disclose per se is not a ground to give rise to justifiable doubts. And I noticed that my friends, and I also note in passing that my friends have referred to the IBA guidelines, and he said that the orange lists are, well, in some degree, give rise to justifiable doubts, but the verbatim wording, the exact wording of the orange list description is that it gives rise to, it may give, in some circumstances, gives rise to doubts, not justifiable doubts. And then it is for the applicant of the challenge to say that those are justifiable doubts. And as have been pointed out pointedly by the members of the tribunal, those are not justifiable doubts. The whole list of the 5 challenges are nothing but ordinary life of barristers, or more generally, legal profession in Hong Kong. And I will rest my case on that. Thank you.
Thank you very much, counsel. So at this stage, after hearing the parties, usually the tribunal will take a coffee break and have their deliberation. Because we are in this law arbitration, it's not possible to kick everyone out of the room. So we will we'll pretend that we already have our deliberation, and maybe I'll say a few words on the ruling on the jurisdiction. And Ms. Thompson, feel free to chime in. On the jurisdiction point, my view, and I think it's Mr. Mackay agrees with me, that the tribunal should favor an interpretation that will keep the arbitration agreement alive and valid. It is the tribunal's view that it is very unlikely that businessmen will agree to a law to apply to the arbitration agreement, which will make it invalid, because that would deprive the arbitration agreement of any purpose. So on the jurisdictional point, the tribunal disagrees with the applicant and dismisses the application. On the second part, the arbitrator challenge is really up to me as to whether I want to resign or not. Personally, I think according to the IBA rules, if there's any doubt that whether an arbitrator should disclose the circumstances that may or may not give rise to justifiable doubt, the preference is to disclose. And I agree that as a matter of prudence, the tribunal should have disclosed the relationship. But I also note that in this case, there's no complaint as to any actual bias from Mr. Park against me. It's more a matter of apparent bias from my failure to disclose, as well as the relationship that the professional relationship that I have with Ms. Mao. In the circumstances, I personally do not think there's any justifiable doubt as to my impartiality and independence. But having said that, I will not resign, but having said that, I'll defer the final decision to the chairman of CMAC. And pending the decision pursuant to the CMAC rules, I shall continue to be the presider of this arbitration and continue to hear the second part of the arbitration in relation to the merits. So, Ms. Thompson, Mr. McCall, do you have any comments?
Agree.
Agree.
I endorse your views.
Thanks very much. Okay, thank you, Ms. Mao, Mr. Park, and Ms. Wong. Shall we move to the second part of the hearing?
Thank you.
Thank you.
Yeah, may I now invite counsel for the second group to the stage? Thanks very much.
May I just say a few words?
Yes, Ms. Thompson, we can hear you.
Yeah, I just wanted to say, I know that this is a mock arbitration, but I think we need to be conscious, or just for the information of the attendees and the public who are watching this. We've got to the situation now where in a pandemic, a lot more arbitrations and hearings are taking place virtually, including international arbitrations. So you've got different time zones. And I know that it often happens in arbitrations where submissions and documents that are supposed to be served well ahead of time gets served very late in the day. So for example, the written submissions by the councils, I'm not blaming anyone in this case. I know you've got your day job. This is just a mock. But because I'm in a different time zone, I didn't get to read some of the submissions properly. And so just a word that usually tribunals can get quite upset when submissions are not received in time, because it also puts the member of tribunal who wasn't able to read ahead of the hearing in the disadvantage of having to catch up during the hearing on if it had been received earlier, then the tribunal concerned would be better prepared for the hearing. But I'm just saying that because things have changed now virtually, parties these days have to take into account that there are more virtual hearings, and some members of the council, well, not just council, but also arbitrator, like in this mock, where we have one member of tribunal, one member of the council in a different jurisdiction and in a different time zone. They have to take that into account when serving documents and wanting those individuals to have notice of their submissions and contents of it well ahead of time. Just a note for the attendees.
Yes, thank you, Ms. Thompson. I mean, I absolutely agree that in real life, it's very important to make your submissions timely, and so that the tribunal can read it before the hearing. I mean, that's a very good reminder to all of us. So as to the last time, since in real life, we will have already known every one of you.
Yes.
The audience may not. So for their purpose, may I ask the council to introduce your respective teams?
Yes, members of the tribunal's audience. My name is Richard Learn, and my co-counsel is Mr. Ronald Penn. We are acting for the ship owner in this case.
Thank you, Mr. Learn.
My name is Nick Luxton, and my co-counsel is Mr. William Learn. We're acting for the charterer in this case.
Thank you, Ms. Luxton. Ms. Thompson, do you hear them okay?
Yes, perfectly, thank you.
Thank you very much. So without further ado, may I ask Mr. Leung,
yes.
Will you start first?
Okay. Yeah, presiding arbitrators, members of the tribunal. This case is between the ship owner and the charterer. Our client, the ship owner, is claiming for indemnity for the compensation that it paid to the second officers because of the illness that he contracted, the COVID-19, after visiting the port in Indonesia. And of course, the charterer, on the other hand, say that we have delayed the voyage, and then they want to counterclaim the loss of time incurred for the delay in the voyage because we deviate the route and then discharge the second officers in the nearest port so as to limit or reduce the further harm that may cause to the ship, the voyage, and the cargo in question. So members of the tribunal have already heard the evidence, and for the benefit of the audience, we want to highlight certain pertinent facts of the case. The pertinent facts which has been accepted by the tribunal is that 2nd of August 2020, the loading was completed. And then on 4th of August, just 2 days later, the port in Kalimantan, Indonesia was declared to be an affected port and was closed its operations for 2 weeks. So the point I want to emphasize here is that the announcement was not made because of certain things happens on that day, but was due to many incidents of COVID-19 contracted cases beforehand. So this is the markers that I would like to draw the tribunals to. The second important fact, which is, as the tribunal has heard from the witness from the crew member, is that during the discharge of the second officer, the ship owner, because of the urgency, we discharged it to the nearest port. And then now the charterer, my learned friend's client, want to argue that, well, we should be informed, we should, had that been done, we would nominate a nearest port which can reduce the voyage time. We will address this later on. And then the third important fact is that, of course, the crew members were subject to extensive cross-examination by my learned friend. And then, of course, during the evidence adduced before the tribunal, the crew members will say that they will adhere to the general guidelines for protection, wearing gloves, wearing masks, and also do the hygiene cleaning all the time during the loading operation. And of course, one may hear the evidence from the officer saying that, well, is it okay, or is it good enough, or could that be perfect? And the answer from the crew member was that, well, systems could have been improved. So I would say something in that in due course in my submission. So without further ado, basically the issue in this case is about whether the port we say is safe or unsafe. And then if the port is considered to be unsafe, in short, then we will invite the tribunal to rule in our favor and then order the charterers to pay compensation. Of course, the other side will counterclaim us for the delay. And then the whole issue turns on whether the short deviation of 10 days or 8 days, if they can reduce it, is it reasonable or not in the circumstances of this particular case? So I will address on the point of whether the port is safe or unsafe. and my co-counsel, Mr. Pang, will address the tribunal on the issue about the deviation, reasonableness of the deviation. So we say that the port of Kalimantan was an unsafe port is quite obvious and relied that this is we have the safe port clause in the Charter Party. Although the wording used is endeavor or due diligence, not so absolute as we can find in some other shipping contract. But still, we say that in the circumstances of the present case, we are home. And I'll elaborate in due course. The very first point that I would like to emphasize is that in the course of loading, the port was about to be locked down already. So once the completion was made, once the loading was completed, then 2 days later, the lockdown announcement was made, and the whole port was suspended in its operation. And one thing that members in your common sense will know that this won't happen all out of a sudden. Everything must have, looking at the number of cases contracted COVID-19 over a period of time before the port authorities eventually declare it's totally unsafe and it's better to close it down. So one needs to look at the circumstances which evolve over this short period of time. And we say that this fact is very important and that it makes it very dangerous, the port in Indonesia as a safe port. And the next point is that due diligence is the, well, as a matter of common ground, this is the duty of the charterer in nominating the port for the ship owners to carry on with this job. And in that duty, they should nominate, they should also look into the fact and ascertain the situation of the port in question. Well, they should not, in the circumstance of this case, saying that, well, this is not yet declared, and then I can just, well, leave an open hand without checking and looking at whether there is an uprising statistics of cases contracted COVID-19 in question. Because this danger is really there, because if there is an increasing trend of contracted cases in the port in question, that make it unsafe and that make all the crews of the ship dangerous in the whole operation. And as the evidence reviewed before the tribunal, there is no particular warning, no particular precaution. All that the charterers have done is that you went there and do the loading. They have not communicated to us as to the statistics of whether there was any particular issue about the growing number of COVID cases in Indonesia. And more important to the fact is that at the early stage of the loading, the outgoing chief officers had already tested positive of that disease. Pausing there, we want to emphasize that for the ship owner's perspective, there were checking and testing of the crew members on a daily basis. Certainly, all the crew members were clean before they arrived at the loading port in Indonesia. And the real fact is that the outgoing chief officers, after having arrived there for a short while, have contracted. Of course, he's outgoing. But then the second officers taking over. And still, the second officers, after the ship were on the way to its destination, was found seriously ill. And therefore, the ship owner had to make a very critical decision. One, to let this disease spreading out to other crew members, or for the common good of all parties, the ship, the charterer, and the cargo, and the party that is waiting for the cargo, to control the situation and then discharge the contracted crew member as earlier as possible at the nearest possible port in question. So the inference that can be drawn in this particular circumstances is that, well, certainly there was no symptom of contraction whatsoever in the previous voyage before coming over to Indonesia. And then after staying in Indonesia for this loading period of about a week, 2 crew members were contracted. And bearing in mind that COVID has been in place for about more than a year since the end of 2019. And the crew members have already accustomed to the general practice of keeping hygiene and also observing very strict conditions of special care in the loading and then transportation of goods, etc., and communication with port authority staff. So these are the things that they observe. And certainly the tribunal has heard the evidence, although the opponents try to cast out as to, well, you may be careless, you may be contracted by yourself, but there's absolutely no evidence which can point a finger against the crew member. So in that case, we say that the port will not be safe unless in the relevant period of time, the vessel can reach it, use it, and return from it without, in the absence of some abnormal occurrence, being exposed to danger which cannot be avoided by good navigation and seamanship. Of course, I'm sure that members of the tribunal with the expertise in shipping, this is the Eastern City case definition of what is the safe port. We say that there's nothing to do with the good navigation and seamanship. It's about whether they have informed the ship owner that the situation is deteriorating in the port or in Indonesia, and that we may have to take extra precaution, or we may have to suspend the loading operation for a period of time until the number of cases contracted reduced to a reasonable degree. And if the vessel was asked or nominated by the charterers to visit the port contaminated by the plague, I think the case law support that the port is considered to be unsafe. And we will cite the case of Cemampa versus British India Steam Navigation Company Limited. I'm sure that members of the tribunal is familiar with this general principle. Unless the tribunals want me to express or refer to certain passage, I will just leave it there. And the proximity of the lockdown is a fact which we would ask the tribunal to accept. We will also ask the tribunals to find in our favors that the charterers has failed to do its due diligence to nominate a safe port. As a result of the breach, we also mentioned about the charter party also contained the BIMCO infectious and contagious disease clause in this case. And of course, members of tribunals are familiar with this BIMCO clause on contagious disease. Basically, this is involved in 2015 out of the Ebola disease, and it, generally speaking, imposed that if the owners was forced or to asked by the charterers to visit a port which, well, has contagious disease and the port is an affected port, then the common sense will say that they should be responsible for any additional expenditures that would be incurred in that situation. And I think I don't need to trouble the tribunals about what's the meaning of disease, what is the meaning of affected port, affected area. Disease, I think COVID, I think is, we all accept this is a very infectious and contagious disease. What's probably may be argued by the other side is that whether at the time of loading, the port in Indonesia is an affected port or not. Certainly the fact revealed that the port was declared an affected port 2 days after completion of the loading. We say that because of the close proximity of the time, certainly we would invite the tribunal to say that it should fall within the meaning of affected ports under this simple clause. So without ado, unless I can hear further questions from the tribunal, I will pass the time to Ronald, Mr. Peng, to talk about the deviation issue.
Yes, Ms. Thompson.
Mr. Leong.
Yes.
Thank you, Mr. Leong. Can I just ask you, so I have prepared for myself a chronology based on the agreed facts that's been received from parties. So in terms of time, at what date do you say that the charters should have cancelled the order for that port and issued new orders? Are you saying 24, 26? What date?
I would say that when the chief officers was contracted and now going chief officers was contracted, that time they should have known this is dangerous to continue with the loading operation.
So that would have been the 26th, is that right?
Yes.
Okay, thank you, Mr. Leong.
Yes, Mr. Becker.
Thank you, Mr. Lang. Just two very small questions. One is, what is the normal incubation period for COVID? That's, if you can please tell us. And the other thing, I understand this is a void charter and the load port was a named port which the owners were fully aware. Am I right in that?
Say again, sorry.
This was a void charter.
Correct.
And the owners were fully aware of the named load port. Were they fully aware? Do you agree with me that they were fully aware? That's one question. And the other one is, what's the normal average incubation period for COVID-19?
Well, on the first question about the incubation period, I would not venture to go into this evidence. I'm not expert in these matters of medical science. Of course, what I can say in that regard is that generally speaking, according to the newspaper, which I mean, if this can be regarded as judicial notice, the normal incubation period from reading general newspaper reports about the COVID is about 7 days to 14 days. I think that is the general period that we normally see in newspapers reports. So that is how I answer. But of course, I would need to qualify that I'm not in medical science and I can't give expert evidence in that regard. On the second point about the voyage destination, this is a voyage charter. We do is designated there, so I can't say that we are not aware this is the loading port.
Thank you, Mr. Lam. Mr. Peng.
Thank you. Members of the tribunal, I'll be dealing with mainly two issues today in my submissions. Firstly, I will be dealing with the deviation issue. And then as agreed with the opposing counsel, I will do our reply submissions to their arguments and written submissions given to us and forego our opportunity to make any reply submissions, as is the usual practice in the hearings such as this. In respect, I also do know the time, and in fairness to opposing counsel, I will try and keep my submissions as brief as possible and deal with the issues with haste. On the first issue, the issue of the deviation route, our main submission, the thrust of our submissions is that there was actually no deviation at all, as the deviation and the change of ports was due to an emergency and to protect the crew members of the ship. Secondly, we rely heavily on Article 4 of the Hague-Visby rules in that any deviation that amounts to, for the purpose of saving or attempting to save a life, does not amount to a proper deviation and can be excluded in such a calculation. And as that point is relatively short, I will leave it at that. As in our opinion on the claimant side, this point is quite straightforward and does not need any elaboration. As such, I will move my focus on to the submissions of my opposing counsel. In particular, I want to deal with the issue raised by my learned friends in respect to the seriousness of the second officer's illness. I think the learned tribunal will gladly agree with me that the fact that one of the officers contracted COVID cannot be underplayed and clearly falls within the ambit of seriousness. And the fact that not only is COVID deadly, both life-threatening and highly contagious, must mean that the claimant must be required to act with haste to ensure that it does not spread around the ship. As a result, it is the claimant's submissions in this regard that the assertions by the respondent that the seriousness, the illness contracted by the second officer does not amount to serious is without any basis. In addition, there has been no medical evidence adduced in this regard to downplay the seriousness of COVID-19. In fact, I think everyone can agree to one fact that the COVID-19 issue must be dealt with at full force and as quickly as possible. The second point I want to address is the point on evidence. My learned friend in his written submissions dealt with a point regarding evidence elicited from the second officer during cross-examination. He states that the choice of the port was not based on whether or not the port was nearest to disembark the second officer for treatment, but also rather for convenience of bunkering and uploading necessary accessories. He goes on to say that the port itself might not have been the nearest port to disembark. Of course, I invite the learned tribunal to look at the transcript of these proceedings and understand from the evidence that clearly the second officer was stating that the main concern of the ship owners and the claimant at that point in time is to disembark as quickly as possible. As such, we submit that the characterization that the disembarking was not for the nearest port but for convenience is baseless again and without real evidence. Thirdly, in the opposing counsel's written submissions, one of the issues, it seems that my learned friends are putting the cart before the horse. They submit that there is a factual finding that the second officer's illness is not serious enough to justify a deviation of the vessel. It is submitted, at least from the claimant's side, that this is a matter for the tribunal to decide and not a unilateral assertion that can be made by opposing counsel. Lastly, which kind of segues, my last point really segues back to Mr. Co-Arbitrator's question and the question of incubation. While I do understand the basis of Mr. Co-Arbitrator's question in respect to what is the length of incubation in respect to COVID-19, with respect, and we humbly submit that the incubation period is an irrelevant consideration in regards to COVID-19 and in respect to this case. Firstly, as my co-counsel has pointed out, we are not medical professionals. We are unable to give any opinion or evidence in this regard. Secondly, if there was any issue with respect to incubation period or the prognosis of the disease of COVID-19, medical evidence should be adduced by the party adducing it, in this part, the respondent, and they have failed to do so. Thirdly, I think as COVID-19 is a relatively new disease, the science behind whether or not the incubation period has any impact on whether or not symptoms are exhibited is still up in the air. As such, the claimant submits that the respondent's submission that it is likely that the second officer contracted the disease, and the chief officer is also without any merits and should be disregarded by the learned tribunal. I do note the time, and again, as a reiterated starting point, I do not want to deprive my opposing counsel from any time allocated to them. As such, unless the learned tribunal has any questions for me, I'll leave my submissions to that.
Yes, I suggest Mr. Luston to start because I don't think you have a lot of time.
Thank you. I'll be making submissions on the safe port issue, and Mr. Leung will be dealing with the deviation issue. what I'll start with is that there's a number of facts that haven't been addressed with the tribunal by my friends on behalf of the ship owners. The first is that, and it was picked up by Ms. Thompson, is that the ship owner and the charterers had both agreed that the load port be Kalimantan. It was agreed that that was the port in Indonesia would be the load port, and it was a term of the voyage charter. The second is obviously that COVID-19 is a global pandemic. It was at the time of the loading of the vessel, and it was affecting almost all ports around the world. The third point is that the load port, Kalimantan, was not in lockdown during the cargo operations, and there wasn't any restrictions as well at the time of nomination. Finally, the fourth point I'd make, it was only after the vessel had departed for its voyage to China that the load port was closed due to COVID-19. So it is all after the event. So taking those facts into account, the first principle I'll deal with, we look at the safe port clause, and it's in the materials before the tribunal. It provides that charterers shall exercise due diligence to ensure that the vessel is only employed between and at safe ports. Now, at what point in time shall the charterers ensure that to be the case? And the case law on this is quite clear. There's a decision of the House of Lords in the Evia, which is that the charterer's obligation to nominate a safe port is prospective, and it is in the sense that the safety of the port is to be determined at the time when the load port is nominated. So it's taking it back some time from before the events in question here. And you'll see that in the facts of the Evia, because what happened there was that there was a time charter, and the charterers had ordered cargo to be loaded at a port in Iraq called Basra. But after the time when the vessel arrived, and actually after cargo operations were almost completed, the House of Lords said, with classic British understatement, that hostilities had commenced between Iran and Iraq, which of course was the Iran-Iraq war, which continued for many years. And as a result of that, the vessel was caught in port for over 12 months. The charterers argued that the charter was frustrated. In turn, the owners said that charterers were in breach of the safe port warranty. The House of Lords, however, held in favour of the charterers because the charterers' obligation was for prospective safety as at the time of nomination. We say the same point applies here. At the time when the nomination was made, there was no particular restriction at Kalimantan. It was simply the same as many ports around the world where there was some experience of COVID, but manageable experience. That deals with the first point. I would say, however, on this, there is one further issue as has been identified, which is that given that the owners had agreed to Kalimantan being the load port, that has an impact when we look at the extent to which the charterer's obligation exists, because the owners were fully aware of the particular risks in going to that port. So dealing with that, the second issue is due diligence. And it's quite clear in the contract that it's not an absolute obligation that the charterers had to nominate a safe port. It was a due diligence obligation. And in this instance, there were no restrictions at Kalimantan. The charterers are not epidemiologists. They don't have a particular knowledge of the spread of COVID in particular locations. And it can be said where there hasn't been any local restrictions in Kalimantan, that they exercised due diligence in nominating that port. The third point on this issue is I just want to deal briefly with what my learned Fred said as to the definition of what is a safe port. And he referred to the classic definition in a case called the Eastern City. And that looked at whether a port will not be safe unless in the relevant period of time, the particular ship can reach it, use it, and return from it without, in the absence of some abnormal occurrence, being exposed to danger, which cannot be avoided by good navigation and seamanship. And it's the final phrase there, which I wish to emphasize, is that whether it could have been avoided, any issues could have been avoided by good seamanship. And the risk here in the context of a safe port still requires the owners to take reasonable precautions. And in this instance, the evidence is that the ship owners' witnesses admitted that their procedures for using PPE and for allowing shoreside personnel on the vessel could have been improved. And you will remember that during the cross-examination of the witnesses, there was a photograph produced which showed shoreside personnel in the dining room of the ship enjoying lunch with crew members. Now that quite clearly was a breach of those obligations. Now this was all well known. The issues which arose with respect to COVID and the steps that could be taken to avoid issues were well known at the time when this voyage occurred. And you'll see that in my skeleton argument, I referred to IMO's circular, which dealt with how that ship owners need to comply with the ISM code, to have a safety management system in place which dealt with COVID matters, and then took steps in accordance with World Health Organization procedures, including mask wearing and ensuring restricting shoreside personnel on the vessel wherever possible. And the evidence that we have heard and the tribunal will now deal with shows that that did not occur in this instance. So we would say in those circumstances, it wasn't, even if there was a heightened level of COVID, there was a risk of COVID being caught by crew members on the vessel, that was heightened by the inadequate procedures and precautions taken by the vessel, and that could have been dealt with by properly complying with IMO circulars and the like. So that deals briefly with the Safe Port Clause. I'll just go on to deal with the BIMCO clause, and that you will see that in the instructions. Now, in relation to the BIMCO clause, if you look at subclause F2, it says, the owner shall endeavour to take such reasonable measures in relation to the disease as may from time to time be recommended by the World Health Organization. And subclause 3, any additional costs, expenses or liabilities whatsoever arising out of the vessel visiting or having visited an affected area, including but not limited to screening, etc., shall be for the charterer's account. The point being is that in relation to subclause 3, there still has to be a causative link. It has to be liabilities arising out of the vessel having been in an affected area, and that must be read subject to subclause 2, which is that the owner shall endeavour to take reasonable measures in relation to the disease, as may be recommended by the World Health Organization. And as we've dealt with, and I've just expressed, the evidence is actually that the owners simply did not do that the crew did not take adequate steps to protect against the spread of COVID. That deals generally on the BIMCO clause, but what I will finally look at is an element of causation. And it's a matter which has been addressed by one of the questions by the tribunal. And this is obviously, even if there is a breach by the charterers as to nominating a safe port, the losses that have been sustained by the ship owner must have been caused by that breach. And in this instance, the evidence is that the vessel arrived at the load port on the 24th of July, 2020. The chief officer tested positive for COVID-19 on the 26th of July, only 2 days later. Now, we would submit that this is a remarkably short incubation period. In fact, the CHP in Hong Kong, in its FAQ, states that the most common incubation period for COVID is 5 days. So it is significantly longer. Now, what could have happened, obviously, is the chief officer could have caught COVID at a previous port or from another crew member. Further, the chief officer could have passed on COVID to the second officer, who then had to be taken ashore after the vessel had sailed. And that wouldn't be surprising, given that the crew obviously are living at very close quarters and that officers would be interacting with each other regularly in their work. So we would submit in those circumstances, whether or not these events are necessarily what occurred, it is the duty of the ship owners to prove their case. And in the absence of evidence, we would submit they haven't established any link and that there is no causative connection between the port being unsafe and the losses being sustained. There's one point in reply I would make. I would note that the Ship Owners Council has said that the port became safe at the time when the chief officer became sick. Now, of course, that was during the loading operations. And if COVID was to spread from the chief officer to the second officer, that would simply be too late. And at that point, it cannot be said that the charterer had breached their obligations. Thank you.
Thank you, Mr. Luston. Mr. Leung, I believe you will now address the tribunal on the issue of deviation.
Yes, on the address on deviation, I would say that there's certainly been deviation, and there's certainly been deviation. Such deviation has not been excused by the Article 4 of the Hague-Wisby rules, and that not just there has been no deviation, but also the port chosen, the disembarking port chosen by the owners has not been an appropriate one, and not having given the opportunity to the charterer to have chosen an alternative port. I have given my presentation, given my my skeleton already, and I'm not going to repeat them here. And the fact that I would say that there are various factual matters which have not been proven by the ship owner. If one look at, if the tribunal will look at the factual facts as stated in paragraph 2.2 of the agreed facts, although we are mindful that on the 26th of July 2020, the outgoing chief officer was tested positive for COVID. But on the 5th of August 2020, that was a total of 12 days since the vessel has arrived at Kalimantan at the loading port. Then the second officer was reported sick and developed acute symptoms. And what is that acute symptoms seems to be? It seems to me that my learned friend has quite wrongly assumed that it is necessarily a COVID disease. That may not be so. And acute symptoms, and what is that? What that is? I mean, we have no idea. And also in terms of this illness, medical evidence has to be produced by the ship owner improving what kind of symptom, what kind of illness having caused such acute symptoms. And certainly we submit that absence of any evidence, the ship owner is far from proving his case that the second officer has in fact contracted COVID. The fact that the chief officer has contracted COVID on the 26th of July, 9 days ago, does not necessarily mean that the second officer will equally contract such acute symptoms. And as far as the acute symptoms is concerned, nothing has been produced as to how life-threatening it is going to be. And thus, we say that as there's been no such evidence, the Article 4 of the Hague rules cannot be applicable. And that being so, even if we assume that the second officer had contracted such COVID, and it is had contracted and he need a medical care, and in the vessel, we are mindful that in the vessel the disease may spread quite quickly, and thereby there may be a necessity of the ship to go to nearby port to get medical assistance. But that being the case, the fact that this nearest port to disembark the second officer for treatment, whether that is the most appropriate port in the circumstances, whether the ship owner has done any exercise and in in calculating whether this so-called nearest port was the most appropriate in the circumstances, bearing in mind, of course, the second officer's treatment is essential, but on the other hand, the vessel carrying the cargo has also need to be, the interest has also need to be taken into account. And in the agreed fact itself, nothing whatsoever has been stated as far as the ship owner in taking into account of the cargo interest as well. We say that in the absence of any evidence that the so-called nearest port to disembark the second officer for treatment, we say that this is not, that this disembarking port is not an appropriate port in the circumstances. And thus, we say that deviation has in fact occurred. Now, even the third point I want to make is, even if such port has been held by the tribunal, that this is the appropriate port in the circumstances. The decision of this disembarking port, one salient feature is that the charterer has never been informed of the decision of the ship owner, and thus depriving the choice. It's not a choice; it's a suggestion of the charterer, and therefore we say that had the charterer had this prior knowledge of the deviation by the ship owner, they would have make an alternative choice of a better port, and thereby saving of a number of days, I think 10 days, in terms of the staying in the disembarking port, and we say that without offering the charterer, given the prior knowledge to the charterer of the ship owner's decision, and without offering the charterer the choice of making suggestion of alternative port, disembarking port, and such delay of 10 days has to be borne by the ship owner, and we say that let's see. Apart from that, the vessel has been staying in the disembarking port for a certain number of days, and within the days concerned, there seems to have been evidence suggesting that the ship owner has other activities having been carried out at the disembarking port. So I would submit that the fact that even though the vessel has to be deviated and the second officer has to be disembarked, such disembarking port should not have been chosen, and instead an alternative port should have been, as to be suggested by the charterer, should have been chosen. And as far as delay is, and thus the ship owner has to be responsible for the additional 10 days delay. And that's my submission.
Thank you, Mr. Lau. Thank you, counsel from both sides. And I believe you have taken your cases to the highest, given the bound.
Can I make a one point reply to Mr. Leung's? There is no hospital in the ship. We have the general practice of testing the crews about the condition, whether they have contracted. Of course, that testing may have a result indicating it's likely to be positive or likely to be negative, but that is not conclusive. Only when the time when the crew members was discharged at the nearest port and then sent to the hospital and then finally confirmed. And the evidence is in the compensation documents disbursement claim. So it's confirmed as COVID, okay? And why we say it's acute symptom, because we only tested the crew at the port, on the spot. We have tested positive, but it cannot be conclusive positive. There is no doctors on the ship. There's no hospital on the ship. So we have to live with the practical world. I'm afraid my friend is living in a different world.
Mr. President, I have a very small question for Mr. William Lam. Thank you very much for your submission.
Thank you.
Do all the ports allow the ships to enter, the ones which are carrying the COVID-infected persons on board? You can go to any port if you have COVID-infected person on your ship?
Well, assuming that the person concerned is infected or highly suspected to be COVID infected, then there is very likely to be restrictions on the entry of the ship into the port.
Thank you. Ms. Thompson?
I'll unmute. Mr. Leung, does it matter whether the crew member who is ill has COVID as long as is very ill or has acute symptoms? Does it matter? Because you make the point that you cannot tell at that stage if he had COVID. That's my first question. My second question is, if you are now objecting to the fact of the deviation and that it took 10 extra days, had the ship owner done what you suggested and not gone and disembarked in the port that they did, how much less time would have been saved? How many days would have been saved as a result instead of that 10 days?
Well, the grief facts, the second question, the grief facts itself is stated is 2 days. In paragraph 5.1.
Okay, so instead of 10 days, it would have been 8 days.
Yes.
Okay. And then about the COVID question?
Yeah, the COVID question itself, COVID is I would say if it is a acute serious illness, I mean, it may need a medical treatment, but on the other hand, it may not be contagious. It may take a longer time to be needed, and so and also the kind of facilities to be available at the port, medical facilities available at the port may not be that stringent and that extensive. So the choice may be much more as far as embarking the second officer is concerned. But whereas COVID is very contagious, and also there may be a restriction for the entry of the ship into the there may be port restrictions for the vessel to enter as well. So if the disease is COVID, then the requirement concerned may be much more stringent.
Thank you, everyone. Because of time, I believe we now have to conclude the Q&A, but it's a very interesting exchange, but we have to continue it another day. So at this stage in real life, I mean, I think most tribunal would reserve their decision and go back and write their award. I mean, I don't think anyone has ever seen any tribunal giving their decision verbally. And in any case, it will have to reduce it in writing anyway in order for the award to be enforceable. But for the purpose of this mock arbitration, as per the procedural issues, maybe I will give some of my views and then my co-arbitrators can supplement. On the issue of unsafe port, and I tend to agree with the charterers that there's insufficient evidence when the port was nominated that the port was actually unsafe, because the outbreak occurred like some time after loading and arrival of the vessel. So it'll be too harsh on charterers if you say they should have known that 10 days later there will be a COVID outbreak. And it's also difficult to argue that charterers did not exercise due diligence in their nomination of the loading port. As to the claim for deviation, I think it is justified to deviate in order to save lives, whether or not the second officer was confirmed to have COVID or not. Mainly because the second officer had developed quite serious symptoms as per the agreed facts. And also at that time, there was at least a very high risk or real likelihood that it was COVID infection. And so I think the owners were justified to deviate, to disembark the crew in order for him to have a medical treatment. And as to the 2 days difference, I think as my co-arbitrator had pointed out, I think there's no evidence that the alternative port would have allowed entry of the vessel carrying a COVID crew member and allow him to disembark and receive treatment. So in those circumstances, and given the state of urgency, we do not think, I do not think that the owners should be blamed, or we should be, or the 2 day difference would mean that the owner's decision was unreasonable. So
dismiss the claim of the party.
So my decision would be to dismiss both cross claims. Ms. Thompson and Ms. McCarthy, do you have any
I
other
agree.
comments?
It's safe port and justified deviation.
Yes.
Okay.
I agree as well. And there's the other point which I thought was rather good is that even if the nomination of the unsafe port couldn't have been, that charters couldn't have said it was unsafe at the time that they did. And then the other point that ship owners said that they should have cancelled the orders and given new orders. And they said the point would have been on the 26th of July when you had the first sickness. But the good point that the charters brought is that the incubation period would have been about 5 days. And that meant the possibility that the infection, the crew member involved may have been infected, not at the port, but somewhere else before arrival at the loading port. And that makes it difficult for ship owners to succeed on that point.
Good. Thank you, Ms. Thompson. It remains for the tribunal to thank everyone for your participation in making this mock arbitration a success. And maybe I would, should I pass the, or should I just conclude the event? Thank you, everyone. Those online, those physically in attendance, thank you for the participation. And we look forward to seeing you next year, hopefully. Thank you. Bye-bye.
Thank you. Bye.
Thank you.
Will we be getting any Q&A from the audience like we do in the past?
Maybe one question. Okay, maybe not.
If we have time.
Yeah. Maybe we can receive questions from email.
Yes,
and because I don't want to hold up everyone, because we have already overrun for 15 minutes.
Okay.
Sorry to those online. We'll let's keep contact. Yeah.
There are a few questions.
Thank you.
From the chat room.
Thank you very much.
Thank you.
Thank you.